Welcome back to the Companies Act 2013 Masterclass by Corporate and Securities Law Compass. Before we begin today's lecture, let's quickly revise what we learned in our previous session. In our last lecture, we understood why Chapter 5 was introduced and how its primary objective is to protect investors from companies raising money without adequate safeguards. We also learned one fundamental principle. Before applying any provision of Chapter 5, first ask one question. Is the amount received by the company a deposit? If the answer is no, Chapter 5 does not apply. That brings us to today's most important topic. Section 231 of the Companies Act 2013, read with Rule 2(1)(c) of the Companies Acceptance of Deposits Rules 2014. Now let me ask you a practical question. If a company receives money, does it automatically become a deposit? No. The law follows a simple two-step test. First, apply the definition under Section 231. Second, check whether the receipt falls under any of the exclusions under Rule 2(1)(c). If an exclusion applies, it is not a deposit. If no exclusion applies, it is treated as a deposit and the provisions of Chapter 5 become applicable. In today's lecture, we will understand the legal definition of deposit and study the first 12 exclusions under Rule 2(1)(c) with practical examples and examination points. By the end of this lecture, you'll clearly understand what is a deposit and, more importantly, what is not a deposit under the Companies Act. So keep your Bare Act, deposit rules, and your notebook ready. Let's begin with Section 231 of the Companies Act 2013. Before we start memorizing all 18 exclusions, let me ask you one simple question. Can a company freely borrow money from anyone whenever it wants? Most students immediately think the answer is yes. But legally, the answer is no. And if you understand this one page properly, almost the entire Chapter 5 becomes easy. The Companies Act 2013 is not against companies borrowing money. The law is against unregulated borrowing from the public. Just imagine a company collecting crores of rupees from thousands of people and later saying that it cannot repay the money. Who suffers? The ordinary investors. That is exactly why Sections 73 to 76A were introduced. The objective of these provisions is very simple: to protect depositors and ensure that companies do not misuse public money. Whenever a company accepts money that legally qualifies as a deposit, it cannot simply receive the money and use it as it wishes. The company must comply with various legal requirements prescribed under Chapter 5 and the Companies Acceptance of Deposits Rules 2014. Now here comes the most important question of this entire chapter. Whenever a company receives money, do not ask what the company has named that money. Instead, ask only one question. Is this legally a deposit? Because in law, the name does not matter. Its legal character matters. If the answer is yes, then Chapter 5 immediately becomes applicable and the company has to comply with the statutory provisions governing deposits. If the answer is no, then these deposit provisions generally do not apply. So this one question completely changes the legal position. Now let us come to the most important rule of this chapter. Rule 2(1)(c) of the Companies Acceptance of Deposits Rules 2014. This rule gives the legal meaning of the word deposit. But notice something very interesting. The rule does not use the word means. Instead, it uses the word includes. This single word is one of the biggest examination points. Whenever Parliament uses the word includes, it intends to create a broad and inclusive definition. The objective is to ensure that companies cannot escape the law simply by changing the label of the money received. Whether the company calls it a deposit, a loan, an advance, or any other name, the law first brings every receipt of money within its broad definition. Another important point is that this rule applies only when money is received by a company. It does not apply to receipts by individuals or unincorporated bodies. Now, a very natural question arises. If the definition is so broad, does that mean every receipt of money becomes a deposit? The answer is no. Immediately after giving this wide definition, the rules carve out 18 specific exclusions. This is the real heart of the chapter. In fact, almost every MCQ, every practical problem, and every case study is based on only one question. Does this receipt of money fall within any of the 18 exclusions? If the answer is yes, it is not treated as a deposit. If the answer is no, it is treated as a deposit and the provisions of Chapter 5 become applicable. So remember this golden formula throughout the chapter. Money received by a company. First assume it is a deposit. Then check Rule 2(1)(c) and examine whether any of the 18 exclusions are available. If an exclusion applies, it is not a deposit. If no exclusion applies, it is a deposit. If you remember only this formula, you will be able to solve the majority of MCQs, practical questions, and case studies from this chapter with confidence. Now that the foundation is crystal clear, let us begin with the first exclusion under Rule 2(1)(c)(1). Before we move to the next exclusions, let me ask you one simple question. Can every receipt of money by a company become a deposit? The answer is no. The Companies Act excludes certain receipts because they come from highly regulated and trustworthy sources. Since these transactions are already governed by other laws, there is no need to treat them as deposits. Let us understand these four important exclusions. Clause 1. Money from government. If a company receives money from the central government, a state government, a local authority, or any statutory authority, that amount is not treated as a deposit. Why? Because the government is considered a highly reliable source. The purpose of the deposit rules is to protect public depositors, and that concern does not arise when the money comes from the government. For example, if a state government grants 10 crore rupees to a public sector undertaking for a highway project, the company has certainly received money. But it is not a deposit because the source is the government itself. Now let us move to Clause 2. Clause 2. Money from foreign sources. A company may receive money from foreign governments, foreign banks, international financial institutions like IFC or ADB, foreign collaborators, export credit agencies, NRIs, or other persons resident outside India. Will this amount become a deposit? No. Why? Because these transactions are already regulated under FEMA and the RBI's external commercial borrowing framework. As long as the company complies with FEMA and RBI guidelines, the amount is excluded from the definition of deposit. For example, an Indian manufacturing company raises $2 million from a foreign bank in Singapore as an external commercial borrowing in accordance with FEMA. This amount is not treated as a deposit. Now let us move to Clause 3. Clause 3. Loans from banks. Any loan or credit facility received from a banking company, State Bank of India, its subsidiaries, a notified banking institution, a corresponding new bank, or a cooperative bank is not treated as a deposit. Why? Because banks themselves are heavily regulated by the Reserve Bank of India. Therefore, there is no need for additional protection under the deposit rules. For example, A private limited company takes a cash credit facility of 50 lakh rupees from HDFC Bank against hypothecation of stock. This is simply a bank loan. It is not a deposit under Rule 2(1)(c)(3). Now let us move to Clause 4. Clause 4. Loans from public financial institutions and insurance companies. A company may receive loans or financial assistance from notified public financial institutions, regional financial institutions, insurance companies, or scheduled banks. Such receipts are also excluded from the definition of deposit. Why? Because these are large institutional lenders operating under separate regulatory frameworks. The ordinary depositor protection under Chapter 5 is therefore not required. For example, LIC sanctions a term loan to an infrastructure company for constructing a toll road. Although the company has received money, it is not treated as a deposit because the lender is an insurance company covered under this exclusion. Now let us quickly revise these four clauses. Money from government is not a deposit because the source is the government. Money from foreign sources is not a deposit because it is regulated under FEMA and RBI. Loans from banks are not deposits because banks are already regulated by the RBI. Loans from public financial institutions and insurance companies are not deposits because they are institutional lenders governed under separate legal frameworks. Remember one simple principle. Whenever money comes from a highly regulated or legally supervised source, the Companies Act generally excludes it from the definition of deposit. If you remember this logic instead of memorizing the clauses, you can easily solve MCQs, practical questions, and case studies from this topic. Before we move to the next exclusions, let me ask you one question. If a company receives money, does it always mean the company has accepted a deposit? The answer is no. Some receipts are already regulated under other laws, while some are meant to become the company's share capital. That is why the Companies Act keeps them outside the definition of deposit. Let us understand three important exclusions. Clause 5. Commercial paper and RBI approved instruments. If a company receives money by issuing commercial paper or any other instrument approved by the Reserve Bank of India, that amount is not treated as a deposit. Why? Because commercial paper is already an RBI regulated money market instrument used for short-term borrowing. Since RBI already regulates these instruments, the deposit rules do not apply again. For example, a listed company issues commercial paper of 25 crore rupees to a mutual fund for 90 days to meet its working capital requirements. Although the company has received money, it is not treated as a deposit because it is raised through an RBI regulated instrument. Now let us move to Clause 6. Clause 6. Intercorporate money. If one company receives money from another company, that amount is not treated as a deposit. Why? Because both parties are companies dealing with each other as commercial entities, not as public depositors. However, remember one important examination point. Although this receipt is excluded from the deposit rules, intercorporate loans are still governed by Section 186 of the Companies Act. For example, XYZ Limited gives an intercorporate loan of 2 crore rupees to ABC Limited. For ABC Limited, the money received is not a deposit. However, XYZ Limited must still comply with Section 186 while granting the loan. Now let us move to Clause 7. Clause 7. Share application money or security subscription money. Suppose a company invites applications for shares. Investors pay share application money. Will this amount become a deposit? No. Why? because this money is intended to become share capital and not a loan. Therefore, genuine share application money is excluded from the definition of deposit. For example, an investor pays 5 lakh rupees as share application money in a private placement. If the company allots the shares within the prescribed period and adjusts the money towards the allotment, the amount is not treated as a deposit. But this exclusion is subject to one of the most important examination rules, the famous 60 plus 15-day rule. The company must allot the securities within 60 days from the date of receiving the application money. If the securities are not allotted within 60 days, the company must refund the entire amount within the next 15 days. In simple words, the company gets a maximum period of 75 days. If the company neither allots the securities nor refunds the money within these 75 days, the exemption is lost. From the 76th day onwards, the amount is treated as a deposit under the Companies Act. Always remember one more important point. The money must actually be refunded. A mere accounting adjustment or transfer to another account is not treated as a valid refund. Now let us quickly revise. Commercial paper is not a deposit because it is already regulated by the RBI. Intercorporate money is not a deposit because it is a transaction between two companies, though Section 186 still applies. Share application money is not a deposit because it is intended to become share capital, provided the company follows the 60 plus 15-day rule and actually refunds the money where required. Remember one simple principle. Whenever money is already regulated under another legal framework or is genuinely meant to become share capital instead of a borrowing, the Companies Act excludes it from the definition of deposit. This single principle will help you solve most MCQs, practical questions, and case studies on these clauses. Before we move to the next clauses, let me ask you one important examination question. Can a company avoid the deposit rules simply by changing the name of the money it has received? The answer is no. The Companies Act looks at the real nature of the transaction, not merely the label given by the company. Let us understand the remaining part of share application money and then move to two very important exclusions. Completion of Clause 7, Share Application Money. In the previous lecture, we learned the famous 60 plus 15-day rule. The company must allot the securities within 60 days from receiving the application money. If the allotment is not made, the company must refund the money within the next 15 days. This gives the company a maximum period of 75 days. Now the important examination point. If the company neither allots the shares nor refunds the money within these 75 days, the amount loses its exemption. From the 76th day onwards, the amount is treated as a deposit under the Companies Act. The company also becomes liable to comply with the deposit rules and may even have to pay interest for the delayed refund. One more point is frequently asked in examinations. Refund means actual repayment of money. Adjustment is not a refund. Suppose the company simply transfers the share application money to a loan account or adjusts it against some other liability without actually returning the money. Will this be treated as a refund? No. A mere accounting adjustment does not satisfy the legal requirement. The amount can still be treated as a deposit. For example, a company receives 10 lakh rupees as share application money on the 1st of January. Neither the shares are allotted nor is the money refunded by the 75th day. From the 18th of March onwards, the 10 lakh rupees becomes a deposit and the company must comply with the applicable deposit rules. Now let us move to Clause 8. Clause 8. Money from directors or their relatives. A company may receive money from its own director. In the case of a private company, it may also receive money from a relative of a director. Such money is not treated as a deposit. Why? Because directors are insiders of the company and are normally supporting the business with their own funds rather than acting as public depositors. However, this exemption is available only if one very important condition is satisfied. The director or relative must give a written declaration stating that the money is not borrowed from anyone else. This declaration is mandatory. The company must also disclose this fact in its board's report. Why has the law imposed this condition? Because a director should not borrow money from a bank or another person and then route that borrowed money into the company by falsely claiming that it is his own contribution. For example, suppose a director gives 15 lakh rupees to his private limited company as an unsecured loan. He also gives a written declaration confirming that the money is from his own savings and not borrowed. In this case, the amount is not treated as a deposit. However, if the director had borrowed that money from a bank and gave a false declaration, this exemption would not be available. Now let us move to Clause 9 and Clause 9A. Clause 9 and Clause 9A. Secured and listed debt instruments. Many students think every debenture is a deposit. That is not correct. The Companies Act excludes certain bonds and debentures from the definition of deposit. First, bonds or debentures secured by a first charge or pari passu first charge on the company's tangible assets are excluded, provided the security satisfies the prescribed conditions. Second, compulsorily convertible debentures which convert into equity shares within 10 years are also excluded. Third, listed unsecured non-convertible debentures issued in accordance with SEBI regulations are separately excluded under Clause 9A. Why are these instruments excluded? Because investors already have adequate protection. In secured debentures, investors have security over the company's assets. In compulsorily convertible debentures, the investment ultimately becomes equity. In listed debt instruments, investors are protected through the SEBI regulatory framework. Therefore, the deposit rules are not required to provide additional protection. For example, suppose a company issues secured redeemable non-convertible debentures backed by a first charge on its factory land and building. Although the company has received money, the amount is not treated as a deposit because it falls within the exclusion under Clause 9. Now let us quickly revise. If share application money is neither allotted nor refunded within 75 days, it becomes a deposit. A mere adjustment of the money is not treated as a refund. Money from directors, or in the case of a private company, from relatives of directors is not a deposit, provided a written declaration confirms that the money is not borrowed and the company makes the required disclosure in the board's report. Secured debentures, compulsorily convertible debentures, and eligible listed debt instruments are not treated as deposits because investors are already protected through security, conversion into equity, or the SEBI regulatory framework. Remember one golden principle. Whenever investors already have sufficient legal protection through another mechanism, the Companies Act generally excludes that receipt from the definition of deposit. This principle will help you answer most MCQs and case studies on these clauses. Before we move ahead, let me ask you one question. If a company receives money during its normal business operations, does it automatically become a deposit? No. The Companies Act recognizes that many receipts are genuine business transactions, not borrowings. Let's understand three important exclusions. Clause X. Employee security deposit. A security deposit from an employee is not a deposit if it is non-interest bearing and does not exceed 1 year's annual salary. For example, a 1 lakh rupees deposit from an employee earning 6 lakh rupees annually is not a deposit. Remember, no interest plus 1 year's salary. Clause 11. Amounts held in trust. If a company merely holds money as a trustee or custodian and not for its own use, the amount is not a deposit, provided it is non-interest bearing. Clause 12. Business advances. A genuine advance received for goods or services is not a deposit, provided it is adjusted within 365 days, unless there is a court dispute. For example, if a customer pays in advance and the goods are delivered within 6 months, it is not a deposit. But if there is neither delivery nor refund after 365 days, the amount becomes a deposit. Quick revision. Employee security deposit, no interest plus 1 year's salary. Money held in trust, company acts as a trustee, not a borrower. Business advance, genuine trade advance adjusted within 365 days. Golden rule. If money is received as part of employment, trust, or ordinary business transactions, it is generally excluded from the definition of deposit under the Companies Act. Understanding this principle is more important than memorizing every clause. Before we conclude today's lecture, let's quickly revise what we learned. Today we studied the meaning of deposit under section 231, read with rule 2(1)(c). The one principle to remember is simple. Every receipt of money by a company is not a deposit. Whenever a company receives money, first apply section 231 and then check the exclusions under rule 2(1)(c). If an exclusion applies, it is not a deposit. Otherwise, Chapter 5 applies. Today we covered the first 12 exclusions: government receipts, foreign sources, bank loans, public financial institutions, commercial paper, intercorporate loans, share application money, directors' funds, debentures, employee security deposits, money held in trust, and business advances. Don't memorize the clauses, understand the logic. If the money comes from a regulated source, is meant to become share capital, or is received in the ordinary course of business, it is generally not a deposit. In the next lecture, we'll cover the remaining exclusions, practical examples, and important examination questions. If this lecture helped you, like, share, subscribe, and press the bell icon. Thank you for watching. I'll see you in lecture 3. Happy learning!